Sophie, are you in Washington, right? You're in Washington, right?
Yes, I'm in DC.
So Sophie is, I would say, one of the top world arbitrators, according to prestigious magazines, not me who am saying this. And she, could I say that you're a fan of Kleros, or that's too much?
I think, given the time that I invest in you guys, yes, I am a friend of Kleros, very much so.
Well, and we are writing an article with Sophie about like all this method of cryptoeconomics. So is this fair or not? And I would like just you, Sophie, to give you your impression about this and how you compare this to how arbitration has been done traditionally in the world.
Thank you very much. First of all, it's a great pleasure to be there, even though remotely. Congratulations on this event. It's a landmark event, and it's a great privilege for me to be a part of it. So I'm an arbitrator in the traditional sense, and I am particularly interested in Kleros' offering of justice and the fact that it relies very much on humans to dispense justice in a decentralized way. And if you are looking at humans dispensing justice, then inevitably the question of fairness will raise its head, as Federico and I are exploring. The importance of this is even greater because you are considering scaling the project up to a more mainstream audience. And so inevitably, the question of what is fair as opposed to the going beyond the incentivized consensus model that you are applying now is going to raise its head, and the fact that it has to be aligned with what the users of your product in the more mainstream area will consider fair. Right now, in the arbitration model that I practice, that is traditionally practiced, obviously we have to follow some rules, the rules of law, the rules of procedure. But at one point, there is a degree of discretion as to when we feel that the application of strict rules is too harsh. And that's where there is a discretion that is entrusted in decision makers to not depart from the rules, but to apply them in a way that is more balanced, more that provides a better sense of fairness. Because users, litigants, people who have a dispute, come to you with the expectation that you're going to do the right thing. And what the right thing is has a component of fairness in addition to the application of the rules. So the search that I think Federico and I are embarking upon in the article, I mean, I don't think, frankly, that I think we agree, both of us, that we won't have definite answers because it's a difficult question. However, I think it's important to have that dialogue, to put that on the table. How can we make the process as fair as possible in those disputes that do not have a simple binary outcome? The other point that I want to raise very, very quickly before ending and taking any questions that there might be, because I know that my slot is short, is something that has just reared its head in discussion groups on international arbitration, and which I discussed very briefly on the Telegram chat, is the question of a use case for Kleros in cases of the coronavirus, which is a pandemic that is preventing courts and arbitral tribunals from meeting up in person. And so the use of something online or on the blockchain to have access to quality justice, even in the absence of physically meeting, would allow, I think, would be a great addition in cases of crisis, just like the one that we are living now. So this is also something that we're hoping to explore on Friday's panel at Columbia University, where Federico will appear along in a room full of arbitration lawyers, very brave of him, and we can discuss obviously these use cases. Federico, is there anything else you'd like me to say at this stage, just before we open to the floor?
I think that was perfect, and I just open to the questions of the audience.
Okay. Please, fire away. No questions.
Everything you said before about the
I have a question. Hello, it's William.
Hi.
Nice to meet you again.
Yes, hi, William.
What is your feeling about the procedural guarantee within a Kleros dispute resolution process? Because from my point of view, it's not it's something very different between arbitration court, which you are subject to like fair trial procedural guarantee, and Kleros dispute resolution course, which is not always be implemented.
So I don't know how much the audience knows about what William is referring to, but in arbitration we have what we call due process. It's shorthand to mean essentially the fact that each party is treated equally in the same manner. So they have an equal right to put forward their case, and each side has an equal opportunity to put forward the documentation, the evidence that they want to put in support of their case. This is a very important part of the process. If you do not follow it as an arbitrator, your award can be annulled or overturned in the courts. I understand that Kleros has its own procedure at the moment, and I agree with William that obviously this is because of the speed of the process and the immediacy of it, we're not talking about the same type of due process at all. And I agree that scaling up, going forward, making the process more mainstream, this is a part of it that will have probably the first thing that will have to be looked at carefully to make sure that both sides are, there are safeguards in place to make sure that the jurors are aware of the fact that the parties need to be treated in the same manner. Now, that said, what that manner will be of being treated doesn't have to be what it is now in the traditional sense. It can be, and online generally, I think the fair treatment of a litigant online is a different thing than when you are in person. But it will involve definitely questions will need to be asked and answered about verifying the authenticity of the evidence, making sure that the evidence is not doctored, is truthful. These are the things that are difficult, the difficult challenges for online dispute resolution at the moment, including blockchain and decentralized dispute resolution. It may be that, and I'm thinking out loud, but it may be that in looking at these questions, there might be value in providing some sort of centralization of verification of the evidence to start with in the first instance, to give some comfort to the users who are not used to this process, and then later on thinking of decentralizing perhaps more fully. I don't know the answer to that question, but I think it's definitely worth thinking about because it will be a great, great part. If you get that right, you have gone a long way towards making the Kleros model legitimate and accepted.
Another question? Yeah, one more question, Sophie, and the last one because we don't have more time.
She's an American lawyer?
She's from Canada, UK.
Okay, but not American.
Not American, I'm afraid.
Oh,
no,
sorry.
I'm just in DC. They let me in. I don't know why.
No, because you understand rules of evidence that are they're more American than European. That's why I was asking.
What's the question? Sorry?
No, the way that you presented the rules of evidence was more
Yes.
American than European.
I'm speaking from the perspective of international arbitration, which is not it's not as civil law, common law as you have in state courts. Yeah. We have, but that said, the American footprint on the taking of evidence in international arbitration is great. We do not have, or very rarely nowadays, in big cases, have a model where the arbitrator does all the evidence gathering. It's very much an adversarial process. So that's why I was talking in those terms. Again, it may be that the Kleros model, when it is scaled up, will want to adopt something different, maybe more inquisitorial, as you are suggesting. What matters is that the parties perceive it as fair, that they consider that they've had an opportunity fairly to put their case. That's completely fundamental. How you do it is a matter of procedure, and if the parties are on board and trust it, they will use it.
So there also has to be rules to eliminate evidence. That's not fairly obtained.
There has to be rules to eliminate evidence that is not trustworthy. There has to be a rule just to make sure that the thing is legitimate. That's what it is. And that's the challenge online, because obviously it's quite easy to corrupt.
It can be legitimate,
patents.
but it's not necessarily, what's the word, the expression? Fruit from the forbidden tree? Poison
Yes.
tree.
Yes, exactly that. Exactly. Are you an American lawyer yourself?
No, just spend way too many time in courtrooms.
In American courtrooms?
No,
Okay, fair
European
enough.
courtrooms.
In courtrooms,
That's
generally.
why I
Okay.
do not like European courtrooms.
All right. Well, I have no view on that.
I do.
Thank you for your question anyway.
Thank you.
Sophie, listen to the applause for you. Thanks a lot, and see you on Friday.
I'll see you on Friday. Bye-bye. Thank you.
Bye-bye.
Merci Sophie.
Merci à toi. Bonne semaine.
Bonne semaine, au revoir.